Bitches out here act like they never seen a pimp before. I raise my hand, they look at it like it's a goddamn croissant. Then BAM! Feel my pimp hand.
Today on Legalese, we will be talking about a Sixth Circuit ruling that says the owner of a car seized by asset forfeiture has a constitutional right to a hearing within 2 weeks of the seizure. Now, this decision provides important protections for property rights and features a powerful concurring opinion by the prominent conservative Judge Amul Thapar. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me bid a special welcome to you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, today, we are going to be talking about a fantastic case that came out of the Sixth Circuit that demonstrated they do indeed know how to keep their pimp hand strong.
I will keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong. Yo, you gotta keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong. Yo, I will keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong. Yo, you gotta keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong.
It's time to move on. Allison's gone. That's a shame, but you gotta keep it strong. Stay a player in this game.
And this is because they chose to smack down civil asset forfeiture by stating if police steal a person's car and try to justify it by claiming civil asset forfeiture, the actual owner of the car must be given a hearing within 2 weeks of their car being seized, in which the police will have to justify specifically why they thought it was acceptable to engage in armed robbery. Now, many of you will no doubt already be familiar with the concept of civil asset forfeiture. This is an unconstitutional and immoral violation of a citizen's property rights in which the police can simply take anything they want without justification and just divvy it up like spoils amongst themselves. Now, civil asset forfeiture is a disease. It is a disease that has clearly infected our property rights, our Constitution.
They could have infectious diseases.
I'm about to infect you with the back of my hand.
But
back of the hand?
So before we get to the actual case we're going to be talking about here today, I do want to take a moment and just talk about what asset forfeiture is and how it undermines property rights and civil liberties for those who may not be familiar already. So asset forfeiture is a long-standing practice under which law enforcement agencies can confiscate property on the mere suspicion that it might have been used in the commission of a crime. Now, in many cases, this allows the police to seize property even if the owner was never charged with a crime, much less convicted of one. And it is in this way that the authorities can seize your car merely because they suspect someone else used it to commit a crime. They can seize your house because people may have sold or consumed illegal drugs in it. Or maybe they just used the phone in your house to arrange a drug deal. Or they will just simply take your cash. If you are transporting cash, they will simply take it because they believe doing that is somehow suspicious. Now, an example of the latter would include a case from my home state in Minnesota that comes to mind, where the police seized $20,000 from the car of a construction worker with no prior criminal record, simply on the theory that transporting that much cash must be evidence that the person is involved in illegal drug dealing. Now, often, these seizures occur with little or no due process protection for the owner. And this enables the government to hold onto the property for months at a time before the owner even has a chance to contest the seizure. Now, as the name civil asset forfeiture might suggest, this is a civil case, not a criminal one, which means that you have no inherent right to counsel. This makes it prohibitively expensive for many people to contest a seizure in court. Recovering property worth several $1,000s, like a car, can cost more in legal fees than the property you recover is worth, and as a result, many owners have little choice but to simply forego any legal challenge to the seizure. Now, law enforcement agencies are often allowed to keep the proceeds of the assets they seize, and it is this policing for profit that creates obvious incentives for abuse. Now, in addition, there are studies that indicate that this practice does divert law enforcement resources away from violent crimes and property crime to drug offenses and other victimless crimes where the opportunity for seizure are more likely to arise. Now, the scale of asset forfeiture abuse is absolutely enormous. In fact, in some years, federal law enforcement alone will seize more property through asset forfeiture than burglars steal throughout the nation. Now, in my home state again of Minnesota, for example, the latest numbers we have, 2021, the gross sales of forfeited property or seized cash amounted to $10,991,198. We're just a couple $100 shy of 11 million. Now, in recent years, many states have begun enacting asset forfeiture reform laws that constrain some of the worst abuses. But unfortunately, the impact of these reforms has been at least partially undercut by actions taken by the former Attorney General Jeff Sessions during a 2017 revival of what is known as the Federal Equitable Sharing Program, under which state and local asset forfeitures are essentially adopted by the federal government, which then shares the proceeds with the state enforcement agencies. This means that even in cases where a state law would otherwise prevent the latter from profiting off of seized assets, the Jeff Sessions policy has allowed that to continue. And while this has attracted bipartisan opposition in Congress and elsewhere, it does still unfortunately remain in place. And one more thing I want to quickly touch on here, for anyone who has been following my channel for any time, you may have noticed a recent shift in my content where I am doing stuff like this, where I'm discussing cases in which the courts have stood up against corrupt police and stood with the Constitution on issues like qualified immunity and civil asset forfeiture. And I thought it might be time to briefly explain why. So the first thing to note is that this will not be me replacing the other kind of content I usually do with new content. This is something that I plan to incorporate into the other more historical or political content that I have always made. Now, my choice for doing this has been very deliberate for a couple of reasons. Perhaps the one we're discussing right now is that I think there is a real tendency for people to see cases of such as, civil asset forfeiture or qualified immunity as being problems that are so endemic and so deeply entrenched, so overbearing in the length to which our government is more than willing to go to screw over its own citizens, that this problem can begin to seem unsolvable. And I get that notion. I really do. The fact is, our government is the kind of person who will fuck a guy in the ass without so much as even the courtesy of a reach around. But despite this, I remain very much optimistic about the future of our country. Now, the reason I make videos like this is because I want to demonstrate that while yes, there are a horrific number of examples of government screwing us over through practices like civil asset forfeiture and qualified immunity, I think people would be truly truly surprised at just how often we are seeing the courts, and increasingly often seeing these several states as well, chipping away at these evils through rulings and legislation. I believe this lack of hope largely comes from an understandable but entirely mistaken view of judicial reform in this country. And this is due in no small part to a belief that I think people have that this kind of major change will have to come from the U.S. Supreme Court, which only hears like 100 to 150 marriage cases every year, and therefore may not address these issues for many years. But what we find is that the lower courts have a very high number of cases, such as the one we're going to be discussing here today, in which, for example, in this case, the circuit court has given an incredibly important precedent checking the power of asset forfeiture. And as I will be touching on, this case is not an anomaly. There has been a rash of federal courts chipping away at these evil doctrines. The one we are talking about today, I have kind of chosen because I think this happens to be one of the most significant and most promising. In many states, asset forfeiture laws allow law enforcement agencies to seize valuable property based on a mere suspicion that it was used in a crime, and then keep it even if the owner was never convicted of any crime. And on top of that, some force owners to wait many months before they even have a chance to challenge the forfeiture in a hearing. This is the case in the case we're going to be talking about here today, Ingram v. Wayne County. Now, in this case, the U.S. Court of Appeals for the Sixth Circuit issued a decision holding that the Due Process Clause of the 14th Amendment requires the government to give owners a hearing within 2 weeks, at least in some cases, when their car is seized through asset forfeiture. Now, the ruling also features a compelling concurring opinion by Judge Amul Thapar, a prominent conservative jurist who is often considered a potential future Supreme Court nominee. But before we get to his concurrence, let's begin with the majority's holding in this case. So, the majority summary of the ruling, which was authored by Judge John K. Bush, is as follows. The plaintiffs allege the government of Wayne County, Michigan has a policy or practice of seizing and holding vehicles while taking months to decide whether to initiate forfeiture proceedings. The plaintiffs claim that they were not provided an opportunity to be heard about the detention of their vehicles and that this failure violates the Due Process Clause of the 14th Amendment. The district court held that the plaintiffs are entitled to the requested hearing. We agree and hold that Wayne County violated the Constitution when it seized the plaintiffs' personal vehicles, which were vital to their transportation and livelihoods. With no timely process to contest the seizure, we further hold that Wayne County was required to provide an interim hearing within 2 weeks to test the probable validity of that deprivation. So, following the lead of several other circuit courts, Judge Bush would conclude that the court should apply a three-part balancing test that was first outlined in the Supreme Court's 1976 ruling of Matthews v. Eldridge. So, the Eldridge balancing test is as follows. It asks, 1, what is the degree of the potential deprivation that may be created by a particular decision? 2, the fairness and reliability of the existing pre-termination procedures, and the probable value, if any, of additional procedural safeguards, and 3, the public interest. Now, in this case, the Sixth Circuit would conclude that all three factors support the property owners, and thus, the latter had a right to a hearing within 2 weeks of the seizure. But it is not entirely clear what might happen in other cases involving the seizure of cars, much less forfeitures of other kinds of property. And in his concurring opinion, Judge Thapar argues for a bright line rule. Instead of a balancing test, he suggests a 48-hour standard, and that this would be preferable to the 2-week balancing test. So he starts by talking about how the Constitution requires the government to provide prompt process before depriving someone of life, liberty, or property. Normally that means a hearing, but Wayne County, Michigan hasn't followed that simple requirement. The county has been seizing cars, holding them for months, and denying hearings to anyone bold enough to ask for them. There's only one surefire way to get your car back. You gotta pay up. How much? Well, $900 if it's the first time the county has seized your car, $1,800 if it's the second time, or $2,700 if it's the third. Even worse, if you challenge the seizure too early or too late, the county can just keep your car. He goes on, Wayne County's scheme violates the Constitution's due process requirement. Constitutional text, history, and precedent show why. History links protection for liberty and for property, and when the government arrests someone depriving them of liberty, the Supreme Court precedent requires a preliminary hearing within 48 hours. I would apply the same rule to Wayne County's seizure of the plaintiff's property. Now, this opinion is, I think, a real tour de force. It very effectively explains the relative history and constitutional text, as well as why property rights, especially when it comes to important property like a car, are entitled to strong procedural protections, and similar in many cases to those provided for liberty itself. Now, he also provides a strong argument for why a bright line rule is preferable to using something like the Matthews balancing test. He says at first, Matthews suffers from problems common to many balancing tests. It requires us to compare values that aren't comparable. First, the individual's interest in more process. Second, the government's interest in providing the same or less process. And three, the risk of error in current procedures and the probable value of additional protections. This test puts judges in an impossible position. It's more like judging whether a particular line is longer than a particular rock is heavy, he says. And there he is actually quoting from Justice Scalia in the Bendix Autolite case from, I believe, 1988. And the judge goes on to say that also, like other balancing tests, Matthews tends to give unpredictable results. With three subjective factors at play, will two judges ever balance them in the same way? I'm skeptical, he says, and unpredictability hurts everyone. It is a problem for government officials who don't know what they're required to do, but Matthews also harms ordinary people. It prevents them from helping themselves. They can't call out government officials for violating their rights because Matthews doesn't say what those rights are. Instead, it says that sometime later, a judge will let them know. A potential court victory years in the future is little solace for the Melissa Ingrams and Stephanie Wilsons of the world who need their cars now for work and school. And apart from those problems, which are common to all balancing tests, he points out, Matthews also suffers from some unique shortcomings. For one, Matthews doesn't account for the all-important interests at stake. Nowhere does the test allow the court to weigh the plain old value of process itself. Basically, of simply knowing why the government has decided to take action against you. For another, under Matthews, everything is negotiable. All process is potentially up for sale. But that's not what the Constitution says. It says you're entitled to process when the government deprives you of life, liberty, or property. That should be where we start and end. Now, the awful facts in these cases do highlight the wrongs of the current asset forfeiture regime in Michigan and in other similar jurisdictions. And here, again, going to the concurring opinion, He says that Wayne County claims that it seizes cars to fight crime and holds on to them for months for the same reason. But the county is happy to return those very cars as soon as it gets paid. That practice proves the county's scheme is simply a money-making venture, one most often used to extort money from those who can least afford it. And he asks us to consider the plaintiff's experiences in this case. And also, if you want to read the plaintiff's experiences, I, of course, on the show notes page, have a link to the case brief, which will have all of the full opinion of the court and all the various documents and motions that were filed. So go and check that out. But anyways, he starts by talking about Melissa Ingram, who is one of the petitioners in this case, who works full-time and goes to school at night. And when her boyfriend asked to borrow her car to find a job, she loaned it to him. Now, rather than using it to find a job, he apparently used the car to pick up a prostitute. And the police pulled him over and seized the car. Now, when Ingram tried to get it back, Wayne County officials told her she would have to wait 4 months for a hearing. So rather than spend the long winter in Michigan without her car, she chose to pay the ransom that Wayne County demanded, which turned out to be $1,355, which was the $900 redemptive fee plus towing and storage. Now, several months later, Ingram loaned her car to her boyfriend again, and this time for him to attend a barbecue. Now here, the police pulled him over again and took the car, claiming the house that he went to was linked to prostitution or drugs. And just like the last time, Ingram demanded her car back from the county, and yet again the county officials told her the best way to get her car back was to pay the redemption fee, which was now increased to $1,800. But the first redemption fee had already bankrupted her. She could not afford to pay another one, and Ingram never got her car back. Now, another plaintiff in this case was Stephanie Wilson, who was a single mom pursuing her nursing degree at a community college. Now, apparently, her daughter's father is a homeless drug addict, and out of pity, Wilson twice agreed to give him a ride, and twice that cost her a car. Both times, the police took her car only moments after she picked up her daughter's father. After the first seizure, Wilson went to the county office building to get her car back, and she was told to come back later. When she did, she was told it was too late, and she had lost her car forever. Then, she bought a second car from a tow yard using her tax refund. The county took that one too. She insisted on a hearing, but the county delayed and pressured her to simply pay the $1,800 redemption fee instead. Now, eventually, a state judge would force the county to return Wilson's car. And finally, the final client in this case was a Robert Reeves. He was a construction worker and a father of 5, and he had his car taken by the county after leaving a job site. And it wasn't for anything that he had done or anything connected with his car. His co-worker had allegedly stolen a piece of equipment from Home Depot. Now, Robert didn't know anything about the theft and had seen rental paperwork for the equipment, but the police arrested him and seized his car anyway. The county held on to his car for more than 6 months, even though they let him out of jail just a few hours later. And the judge asked, does this sound like a legitimate way of cleaning up Wayne County? Or does it sound like a money-making scheme that preys on those least able to fight it? To ask the question is to answer it. Now, the Supreme Court has not yet ruled on the extent of procedural due process protections required in asset forfeiture cases, but when and if they do, I surely hope that they will follow Judge Amul Thapar's approach here. Well, that's all I have for you guys today. Thank you so very much for tuning in to Legalese. Just a reminder, if you would do all of those things that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked it, hit the like button. You know, if you disliked it, hit the dislike button. Subscribe to the channel to make sure you always get updates on new content. Leave me a comment. Let me know what you thought. I really do enjoy reading your guys' comments about the videos and interacting with you as much as I am able to. And also, I have a couple of videos that I know I've been promising you guys on the history of qualified immunity and the First Amendment, and those will be out very soon. They're almost done, so be checking back here soon. Until then, this has been Bob for Legalese, talking about civil asset forfeiture, and of course, as always, Carthago delenda est.
I'm a little house story maniacs. Yes, we do.
I will keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong. Yo, you gotta keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong. Yo, I will keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong. Yo, you gotta keep your pimp hand strong. Your pimp hand, I will keep your pimp hand strong.
It's time to move on. Allison's gone. That's a shame, but you gotta keep it strong. Stay a player in this game. Here to booyah. Look, he's gonna run wild. No time to be shy. Need to stock up on your rubber supply. Give it a try. Grab Houston, start with fellatio. Let the funk flow and get some steak on your hang low. Bang the drum slow and make the whole stutter like John. Yo, F crackhead Bob, F Jackie and Tom. The show is the bomb. Salute you with the bow bow booey. This love shite is screwy. You gotta do your duty and lay down the laws from the queens to pawns to all celebrities and fans. Keep your pimp hand strong, and yo. It's time for some new stick on your hang low. But if your pimp hand is truly strong, then you know when to say no. No to the hoes that lack the cash. No to the piece of ass that